back to the show. This is The Law Show on CL 650.
Once again, I think it's the only time Aerosmith has been played on Sea Isle. Is that true? Living on the Edge. We're talking about family law. David Halkett is a partner of Macquarie Hunter in Surrey and Leah Donaldson, associate. And we're going to get into some individual sort of questions here, and we'll jump right in. The first one, my ex stopped child support payments. My ex stopped his child support check. His lawyer is demanding information about child and stopping the payment to extort that information. Not sure about that. According to our separation agreement, my ex has to keep paying even if there are disagreements. How can I enforce a separation agreement? So basically, somebody stopped paying. How do you keep enforcing it?
Well, the easiest way in that is just register with the Family Maintenance Enforcement Program. They will collect the money for free. And at the end of the day, that it's up to them to come to the table.
So that's garnishing wages and things like that?
And they can withhold your passport, your driver's license. As you said, garnish the wages. There's a whole bunch of things they can do that will get the person to keep making the payments.
And from beginning to end, how long does it take to get them to implement those? Is it fairly quickly? Because, when it comes to having money to look after children, a month or two could make a big difference.
It can take about 6 weeks to register with them while it goes through the bureaucracy. Mm-hmm. And then when you're over, I think it's $3,000 in arrears, that's when they start taking active proceedings.
And $3,000 that could just be 1 or 2 months, right?
Depending on how much is being paid, for sure. The other way you can, of course, because it's an agreement, you don't have an order that's enforceable, right off the bat. You may have to, then you can bring a court action to begin to get the person to pay. It does. The question obviously doesn't say what the unreasonable information was. If it's an adult child, the person's entitled to know whether or not the child is in full-time post-secondary, etc. But the easiest is to go to FMEP and let them enforce the money and then bring them to the table instead of vice versa.
You often hear about deadbeat dads not paying for their child support. Is that common, or is it really just a small percentage that, like, one bad apple spoils the bunch? Is it pretty common that people don't pay up?
I know that there's an entire bureaucracy at FMEP that deals with it. So obviously there's a lot that don't pay. Some may have fallen behind, they've lost work or whatever. I do know that there are some outliers where I was in court once and a person owed about $200,000 and he lived over in Slovakia. Like, trying to get a dime out of him was going to be difficult. I think that the vast majority pay. So maybe 20%, 25% are behind, but there's a huge bureaucracy to collect on it.
Okay, for example, maybe we'll pick a round number. The judge says you need to pay $1,000 towards your 2 children, and and then 1 month comes and he can only give $900. Mm-hmm. So the wife maybe takes $900, and she's willing to let it go because it's not worth fighting over $100. Then a couple months go, and then it's $800, then $700. Like, what is your advice to people when they start slipping down that slope to say, okay, I've let it go. I've been willing to work with you, but now it's just getting to be a habit.
Well, it's, oddly enough, when it's child maintenance, you cannot negotiate away the child's right to the maintenance. The child's maintenance, not yours. That may be payable to you as the spouse, but it's the child's maintenance. So you can't be negotiating that way. I tell them not to negotiate it away. Say the money's still owed, and if they fall further behind, go back to the FMEP and register there. Okay,
now this one kind of picks up on a point you made. Someone's out of work. When the parent who has to pay child support is on employment insurance, do they still have to pay? If yes, do I receive a support check? Like, where do they get the money from if they're on EI?
So they still have to pay support on the amount that they earn. It may be that it's lower. The child support amount is lower. But the parties either have to agree on the lowered amount.
Or go to court,
Or
right?
go to court and then get an order to change it. Because presumably you would have a court order for this amount or a separation agreement. So you have to write something down by agreement or get a different court order to change it.
But you must get some people who are spiteful and just decide that they're not going to work. You're not getting money out of me.
We do see that.
And back to the labor sort of situation where someone could make money under the table. So technically they're collecting EI, but they're still doing jobs on the side. So you must see that once in a while too.
We do. And there's an argument that we can make when we go to court, and that's called imputing income to someone. So just because they're not working, so your example of someone out of spite saying, I'm just not going to work. The court, you can make an application and the court can look at the factors, their age, their education, their work history, and decide that they are capable of earning a certain amount and that they would pay on that amount regardless of whether or not they're working.
So get up.
That's right.
And go to work.
Get off your butt and
As
get
a
a
parent,
job.
you have that obligation. You don't get to just quit your job after you have kids.
That's true. I mean, yeah. Someone's got to feed the kids.
Exactly.
It's going to be you.
So the one issue that arises with someone who's on EI is, did he or she lose the job involuntarily? If that's the case, it might be a reason to reduce it. If the person just quits the job, probably not going to be reduced.
Okay, the next one says, ex lives in Philippines. How can I get divorced? I live here in BC for more than 6 years and have legally separated with my husband in the Philippines. Now I want to have an uncontested divorce, but he is in the Philippines. What it says is not allowed to sign the divorce papers since divorce in the Philippines is prohibited. So how do you get around that one?
Okay, well, that's the biggest issue that's going to arise there is the cost of serving over there. I was early in my family law career, and I had to try and serve someone over in the Philippines, and it was going to be like $3,000 because there's so many different islands. But leaving that issue aside, because she has lived here for more than a year, our court has jurisdiction to grant the divorce. So she could file an application here for a divorce and have the ex served over in this case, the Philippines, assuming she could. He doesn't have to sign anything. If he doesn't respond, she just waits the amount of time and then obtains
the court recognizes it here.
Yeah.
So maybe in the Philippines, if it's a Roman Catholic, they say that we don't recognize divorce, but in British Columbia, it doesn't matter. The divorce has been...
And in some of those countries, you can't get a divorce in the country, but I think internationally, most countries, they recognize the order of another court. So the divorce would likely be valid around the world.
Okay, the next one says, we filed a joint divorce, but I have heard nothing back, and my ex wasn't giving me any information. So I went to the courthouse to find out. The judge wants my ex to pay child support, even though we have the kids for an equal amount of time.
So yeah, as part of the review of the divorce document, so even if both parties agree that they want a divorce and they file a joint application for divorce, the judge and the court reviews the file and to ensure that the children have proper support. And if one party's making good money and not paying any support, they may not grant the divorce order until that there's a child support order in place.
So that's a common sense way of the court looking after the children first.
Right.
Exactly.
So say, we will give you this, but you've got to get this sorted first.
And the Divorce Act says they cannot grant a divorce unless adequate provision is made for the children, which has been interpreted to mean support under the child support guidelines, unless you can justify that it's not necessary or there was violence between the parties that you can't go after the other one for money or something to that effect.
The next one is, I have been separated for 8 years. I recently found out that my ex has remarried, but we are not divorced. So they've separated and then they've gone to get married. I have contacted the Central Divorce Registry in Ottawa to see if there is a divorce on file. He was remarried out of the country. So where are we with that? So somebody's remarried. They've left the country. They were separated here and then got remarried in another country. Where do they stand?
Well, obviously, this person is still married in Canada. Mm-hmm. And so all his or her rights, it doesn't say, all her rights under our acts are still in effect. Internationally, unless it's in a country where you can remarry for a second time, in a common law country, he wouldn't be allowed to be remarried because it's what they call void. It's a void marriage because you can't be married twice.
Okay, so you would just have to prove that you were married before, and then that second marriage would be nullified, right?
Exactly. It doesn't say if the person is back in Canada, if the ex is here. If so, obviously he's committed a crime. You can't voluntarily marry two different people. But she can still proceed with her own issues in this country to deal with him.
So like the last one, you can go through the steps even though the other person isn't here. Yep. Okay, so we have just a couple of minutes left. It's been a great conversation. Always like having you here. There are people listening who maybe are in this situation or maybe know of somebody else or maybe have a daughter or a son that's going through this. What's your top line advice to somebody who's thinking about this?
Well, I think if they're thinking about separation or divorce, before they make the final decision, if they haven't decided, they should seek what their legal rights are. Because some people think that if they leave, they can't get any maintenance. I had someone come to me once says, I'm not entitled to anything because I had an affair. I said, well, no, that's not the reason.
The court doesn't care how you came to this.
Exactly.
It's just that you're there, right?
Exactly. So I think they should get advice, give Leah or I a call, come in and see us. At least they know where they stand, and then you can go from there.
Leah?
Yeah, I would say the same thing. I would say get advice before you have the conversation.
And how do they get in touch with you? Is it McCroryHunter.com?
Yeah, they can go to Macquarie.com.
Macquarie.com.
Yeah, and then just follow the links to the, I think it's personal or individual
personal
law.
services, law services, and then
For
the
individuals.
family law.
Yep.
And then they'll find you.
Yep.
All right. That's the voice of David Halkett, partner at Macquarie Hunter, and Leah Donaldson, associate, talking about family law. Always a fascinating conversation. We'll have you back because there's so many layers to this. It's always interesting to peel them back. I'm Zach Spencer. Thanks for listening. We'll speak to you next time on CL 650.